Good evening and welcome to the launch of Volume 48, Issue 1 of the University of New South Wales Law Journal. On behalf of the journal, I would like to begin by acknowledging the Gadigal people of the Eora Nation, the traditional custodians of the land in which we gather this evening. We pay our respects to their elders, past, present and emerging, and extend that respect to Aboriginal and Torres Strait Islander people gathered here tonight. My name is Ophelia Zhao, and I have the honour of serving as Executive Editor of the Law Journal. It is a privilege to open tonight's event. I would like to give a heartfelt thank you to our premier sponsor, Corrs Chambers Westgarth, in particular Cassandra Gailey, Isabel Delangelo, and Anna Ross. We thank you for hosting us tonight in such a stellar fashion. We're also grateful for the support of Allens, Herbert Smith Freehills, and King and Wood Mallisons for their invaluable support. This issue marks a significant milestone, the 50th anniversary of the journal since it was established in 1975. True to our tradition, Issue 48.1 offers rigorous analysis of pressing legal issues across 10 outstanding articles. To our contributors, thank you for trusting us with your scholarship. A true hallmark of the journal is its entirely student-run body. What makes me so proud to be a part of this fantastic publication is the camaraderie and genuine enthusiasm with which each and every editorial member here has given towards the issue. And to my wonderful executive committee, thank you for your tireless work and teamwork. A special thanks to Fiona Shah, editor of this issue, for her extraordinary dedication. We will miss you dearly on the board. And I would like to give a very warm welcome to Grace Lowe as she steps into the role. Finally, thank you to the Faculty of Law and Justice, especially Professor Rosalind Dixon, Gary Edmond, and the Dean, Andrew Lynch, for their continued support. We are deeply privileged tonight to be joined by Her Excellency, the Honourable Margaret Beazley, the current Governor of New South Wales, who joins us tonight to deliver a keynote address. It is now my pleasure to invite Anna Ross, litigation partner at Corrs, to speak here tonight.
Thank you, and what a delight to see everyone here for such a special event. On behalf of the partners of Corrs, welcome. Welcome to our Sydney office. We couldn't be more pleased to be celebrating such a prestigious and important event in the life of this highly regarded journal. 50 years is no mean feat whatsoever, and we are very honoured to be providing a location to celebrate such a worthy event. A special welcome, of course, to Her Excellency, the Honourable Margaret Beazley, ACKC, our Governor, and to Andrew Lynch, the Dean of UNSW Law School, and of course to the very impressive authors, editors and other contributors to this issue of the journal. We are extremely proud to be a premier sponsor of the UNSW Law Journal and to continue our association with the law school. The relationship between UNSW and our firm is a very valuable one for us and one we treasure. We have a strong alumni presence here. We have many wonderful students with us, with you presently, who will be joining us in due course. And we're absolutely delighted to continue our support of the journal both now and into the future. It's certainly true, and those of you who have read the issue will agree with me that Issue 48, Volume 1 is another incredibly impressive contribution to the history of this proud journal, and a special congratulations to Fiona Shah for her work as issue editor. I also wanted to give a quick self-serving call out to Patrick Ryan, one of our lawyers who's contributed to the journal with his impressive article on assessing pretrial silence, so I commend that all to you for your reading pleasure. It's poignant but important to note, I think, that the theme of public law, institutions and integrity has never been more important, and no doubt never been something that many of us reflect on more than we do presently as we watch what happens around the world, including in some jurisdictions that are not as far away from us as perhaps we once thought. So To that end, I would like to introduce Fiona Shah to address you all on the issues and the topic for tonight's launch. Fiona, thank you.
Thank you very much, Anna, for your warm introduction. Before I begin, I too would like to acknowledge that we are meeting here tonight on traditional Gadigal land. In doing so, I pay my respects to their elders, past and present, and extend that respect to any Aboriginal and Torres Strait Islander friends, colleagues, or members of the community that may be present today. As Anna mentioned, my name is Fiona Shah, and I'm the proud issue editor of this issue of the UNSW Law Journal. This evening, it is my great pleasure to celebrate not only the 10 articles enclosed in this collection, but also the long and distinguished history of the journal itself, which began precisely 50 years ago. Anniversaries, especially when they are golden, are occasions of great celebration, yet they also provoke reminiscence and deep reflection. At this time, when we gather to celebrate the journal's present issue and achievements of the past, I am reminded of an intriguing fact, or more specifically, an almost century-long debate about the future of law reviews more broadly. The foundations of this debate were laid in 1936, well before this journal was founded, when the Virginia Law Review published a famous, or perhaps infamous, article named Goodbye Law Reviews. As that title no doubt suggests, it described law reviews in quite scathing terms, and it disparaged student editors. Quite a humbling read, I must say, and not exactly comforting if you were like me and editing knee-deep at 3 a.m. in the morning. Since then, many others have made similar predictions about the end of student-edited law journals. Critics have grappled with the difficulty of having students choose and edit articles, and they queried, what skills do they bring to the task? Yet, in 1975, an emerging faculty of law and justice at the University of New South Wales established the UNSW Law Journal as its flagship publication. It was led by a board of merely 7 student editors, and contrary to the prediction that law reviews are approaching their demise, this journal has flourished. So much so that it has become one of the chief forums for legal discussion in Australia. This brings into question, why is that so? What are the distinguishing strengths and qualities of our journal? And why has this journal's student-run nature been so integral to its success? And with this awareness, how should we strive to sustain the journal's longevity for the years to come? This brings into question, while there may not be one clear answer, my experience as editor over the past 14 months has certainly given me a few insights. From its inception, the journal's clear ambition has been to publish first-rate legal scholarship. A perusal of the past pages of issues will reveal work that is consistently novel, perceptive, and instructive. They confront the deeper and more difficult questions presented by the subject and compel readers to do the same. The journal is also one that thrives in the face of change. It pursues issues of contemporary legal significance, it listens to new arguments, and it responds to changes in legal thinking. In just 50 years of existence, the journal has witnessed the arrival of the federal courts, the emergence of administrative law, and has mapped various developments in the interpretation of our Constitution. It has provided a voice of reason and a dutiful record through these and other tumultuous changes. Our online forum has allowed the journal to play an even more responsive part in legal discourse. Its short-form pieces are no longer limited to the traditional essay form and benefit from a faster publication cycle. Importantly, since its early days, the journal has had a generalist focus. It takes all areas of law as its province. That choice is intentional, and one that epitomizes our commitment to fostering legal debate across a variety of issues. With that realization, in fixing the theme of this launch, we have sought to highlight that a common thread of concerns emerge in the 4 lead articles. Their novel arguments about referendum success, integrity bodies, judicial review, and prior restraint are made. They reflect pressing issues about public law, institutions, and integrity more broadly, which will remain topical in the years ahead. And of course, the journal has prospered for a remarkable half-century because of all those who have participated in its work throughout the years. In particular, I thank the 11 authors of issue 48.1 for entrusting their work to the journal, and I extend my gratitude to the generations of academics, judges, and practitioners who have contributed articles since 1975. The longevity of the journal is also no doubt attributable to the diligence, inquisitiveness, and collegiality of our voluntary student board and executive committee. They spent grueling hours hunting down seemingly unfindable sources to verify every in-text proposition and every citation in this issue's 374 pages and 2,321 footnotes. The importance of these efforts must not be understated. Scholars bear a responsibility to produce accurate work, and they must combine with editors to ensure that it is upheld. So in riposte to those who question the calibre of student editors, I confidently say that it is their tireless commitment to a high editorial standard upon which this journal has thrived. My sincere thanks also go to our Dean, faculty advisors, and premier sponsors for their ardent support of the journal and proud commitment to our independence. I especially thank Corrs for hosting us tonight with such generous hospitality. With that said, I am now left with one final duty as editor of this issue of the UNSW Law Journal, and that is to introduce our keynote speaker for this evening. We are incredibly honoured to be joined here tonight by Her Excellency the Honourable Margaret Beazley, ACKC, Governor of New South Wales. Her Excellency graduated from the University of Sydney with honours in law in 1974. Shortly after, she was called to the New South Wales Bar in 1975, where she went on to take silk in 1989. Her Excellency's judicial career too began early, and it was a career of various firsts. She was the first female judge solely appointed to the Federal Court in 1993. She later became the first female member of the New South Wales Court of Appeal and subsequently its first female president. It was in 2019 when she ended this role and became the 39th Governor of New South Wales. In the midst, she was made a Companion of the Order of Australia in 2020. It is difficult to think of a more fitting speaker for tonight's celebration. And in saying this, I'm actually very much looking forward to hearing from Her Excellency tonight, so please join me in bidding her a very warm welcome. Thank you.
Fiona, thank you. 50 years of a law journal. I stopped counting how many years of a law career, I have to tell you. Did I learn anything? One never knows. May I also commence in the tradition which I have in recognising the traditional owners by greeting you all in their language. Bujari Gamarua, Dian Babana Gamarada, Ron Gadigal Nura, and I pay my respects to their elders past, present and emerging. Lawyers, more than any other section of the community, are likely to be familiar with the functioning of the great institutions of state, the Parliament, the Executive and the Judiciary, the three pillars of our democracy underpinned by the rule of law. A statement of democracy in those terms might be categorised as a statement in gross, the big picture without the detail. An examination of the structures of democracy is a worthy pursuit and, as I think has already been mentioned, perhaps in today's world, is of some urgency. But an understanding of the functioning of democracy calls for detail. The theme of the 50th anniversary edition of the University of New South Wales Law Journal, Public Law, Institutions and Integrity, whilst directed to three separate streams of discourse, nonetheless brings together the essential workings of entities and processes within those three institutions of state. And the detail comes in the chosen subject of each contributor's discourse. In absorbing the detail of what can only be described as 10 excellent contributions to this anniversary edition, it seemed to me salient at the outset to examine what is meant by an institution. In doing so, I turned to the lawyer's crutch, the dictionary, emerging in England principally in the 16th century in response to the rise in literacy amongst the general public following the invention of the printing press and the consequent wider dissemination of the printed word. In social terms, the emergence of the dictionary for use by the populace was momentous, giving structure and consistency to the language, enabling all levels of society to interact and communicate in commonly understood terms. Indeed, it might be said that the dictionary, if not an institution in itself, had become part of the workings of that larger institution, the English language. Accepting that the dictionary had become widely used as an integral part of the English language, in effect providing the detail of that larger institution, it's apparent that institutions are not confined to state structures, but comprise a range of entities, processes and practices which are integral to the functioning of society. This is serious business, or is it? One can think of numerous examples when it's not necessarily the case. Take, for example, the Fool, a veritable institution within Shakespeare's works, but having a purpose beyond mere comic relief, that of a truth-teller, a device for commenting on the actions and motivations of the characters within the story, often characters who play a role, as it turns out, in the institutions of state. It was likewise with that famous early dictionary, Samuel Johnson's Dictionary of the English Language. Johnson well understood the power of language and used it as much as a tool for ridicule and political sledging and some occasional self-deprecation as he did a source for the precise meaning of words. For example, Johnson described a lexicographer, as he was, as a writer of dictionaries, a harmless drudge that busies himself in tracing the original and detailing the signification of words. Oats in his dictionary were defined as a grain, which in England is generally given to horses, but in Scotland supports the people. Monsieur was a term of reproach for a Frenchman. Of more contemporary relevance was Johnson's definition of an excise. According to Johnson, an excise was a hateful tax levied upon commodities and adjudged not by the common judges of property, but wretches hired by those to whom excise is paid. Not a definition of the ATO, but you know what I mean. A tariff, as we also know, is a tax, which, as defined more recently on the online tool Investopedia, is imposed by one country on the goods and services imported from another country to influence it, to raise revenues, or to protect competitive advantages, although it's in that last sense that it's most commonly used. However, it would appear that according to modern American economic theory, a tariff is a mechanism for eliminating trade deficits with its trading partners. And the methodology to achieve this can be found in that other online tool, ChatGPT, namely by taking the trade deficit with country A, divided by the value of imports from country A, and divide the result by 2, and then apply a percentage. There are other institutions which we might take as settled and uncontentious, but which nonetheless, over the years, has been able to stir the ire of some or completely change social norms. The humble fork is an example of the former, which the clergy of the 11th century equated to the devil's pitchfork, and therefore should never be used as an instrument with which to eat. And the institution of marriage is an example of the latter, where the recognition by the state changed an already existing societal norm by effectively a fairly simple definitional change, the use of words, but always within a definition. Institutions, almost by definition, are historic and of some antiquity. Thus, something that has survived for over 100 years might be thought of the right to be called an institution. The Country Women's Association, of which I'm patron, would fall into that category, and so they think of themselves in that way. And the same could be said of law school journals, although the mention of the Country Women's Association and law journals in the one sentence is rare. Indeed, one might think it is sacrilegious, at least so far as the Country Women's Association is concerned. As to law journals, the history of their emergence is somewhat obscure, but it is perhaps unsurprising that one of the earliest came out of Harvard. Volume 1 was published on the 15th of April 1887, significantly at the instigation of the renowned jurist Louis Brandeis, then recently graduated from Harvard and who would later go on to serve on the United States Supreme Court for 23 years. That first journal was published 70 years after Harvard Law School was established. Editors of the review have included 8 Supreme Court justices and 1 president, not the present one, Barack Obama, in case you weren't sure. Now, Sydney University Law School was established in either 1855 or 1890, depending on how one defines a law school. But the first volume of its law review was published nearly a full century later in 1953. Oxford University's undergraduate law journal seems, I think, to have been published first in 2009, whereas a formal law degree was established in that university in the 1870s. So whether we consider the Law Journal itself an institution, we can say that they have become, at the least, an embedded and valuable part of a law school within the institutional context of a university. It was said in an article in Unicon, in which the then Mr. John Baston and Mr. Julian Disney featured, the title of Mr. itself, 50 years on, indicative of a past institutional salutation, that when the University of New South Wales Law Journal was launched, it was the mark of maturity of the university, and this was a mere 26 years after the university was established, but most significantly, only 4 years after the law school opened. The Honourable Sir Lawrence Street, Chief Justice of New South Wales, said in his foreword to that inaugural volume that there is a full measure of justification for the law school of a university when it reaches maturity and gathers about it a sphere of influence to produce its own journal from the resources available to it. The law school of this great university has reached that stage, and that really is a significant achievement. Indeed, the rapidity with which the University of New South Wales Law School was able to produce its first law journal speaks volumes, and now 48 volumes, not only of its maturity, but of its approach to legal pedagogy that facilitates and engages disciplined analysis of how and why the law functions. Founded in that approach is an invitation to challenge existing institutional behemoths and consider the case for reform. The journal provides the perfect medium in which to do that, as I found on reading the articles in the 50th anniversary edition. Indeed, as I did so, I was reminded of the comment of the pioneering Australian sociologist, Dr. Jean Martin, that for a long time, institutional mystique has succeeded in concealing the fact institutions often don't do what they are supposed to do. The scholarship underpinning this volume, as with its predecessors, unravels some of that mystique. An attempt at a cursory summary of each article would do justice to none. Yet so drawn was I to each by the depth of scholarship and the quantitative and qualitative analysis that I do feel compelled to proffer at least some very brief observations. Paul Scott's examination of the underlying reason for the 75% success of state referendums should be prescribed reading for any government, state or federal, contemplating holding a referendum. As he argues, it's not only bipartisanship per se which underpins a referendum's success, it is neutral, bipartisan information and education available to the voting public. It's a very important article. Are judicial commissions worth the significant administrative cost necessary to support a statutory body that in New South Wales, given that in New South Wales only 3.6% of complaints are substantiated in whole or in part? Joe McIntyre's analysis informs us that the problem may lay in the model and not in the existence of the institution itself. Harishi Garadia posits that judicial review is itself an institution and questions whether, in the different approaches to statutory interpretation, democracy may be compromised in the manner judges interpret or misinterpret the will of Parliament. An important question raised by the author is whether judges should make policy in the manner in which they interpret legislation, something which Justice Kagan found abhorrent in her dissent in Loper Bright Enterprises and Raimondi last year, in which the United States Supreme Court overruled the Chevron doctrine. The complexity of the implied freedom of political communication resurfaces in Catherine Yu's article on prior restraint and protest regulation. The incursion a decade ago by the hitherto inviolable right to silence of an accused by the incursion by Section 89A of the New South Wales Evidence Act, a provision which was strenuously opposed by both the profession and academia at the time of its introduction, has ironically largely lain silent ever since, subject to but a few judicial decisions. However, it lurks there for the unsuspecting unless they read Patrick Ryan's critical review. Well done, Patrick. A particular strength in Griffin and Marchant's article, Paying It Back, on litigating First People's stolen wages in Victoria, is its exposition of the injustice of the state-condoned wages theft and the recognition that redress has thus far fallen on the unhelpful altar of legal doctrine. They remain hopeful, and my memory went back to Love and Tom and what that changed in the discourse in relation to the Aboriginals' connection to the land, but the authors urge the necessity, nonetheless, to find a solution. Why is this important? Well, the answer should be self-evident to all of us. Injustice is debilitating, not only for those affected, but indeed for all of us. Injustice is merely and severely debilitating. Then there's the elephant in the room that recently roared with the passage of legislation in December 2024 subjecting lawyers to oversight by AUSTRAC in respect of compliance of the Tranche 2 anti-money laundering laws. Piecemeal reform rarely achieves what good legislation should achieve: a cohesive regime for the subject matter it governs, a point made with great clarity by Scott Donald in his excellent article, which unravels the complexity and inefficiencies of a system which was implemented for the greater good of society as a whole. Joachim Dietrich's analysis of how courts infer causation for tortious liability, and again, gee, they hit the judges, don't they, these students? And how judges' biases and prejudices, be they conscious or otherwise, may contribute to the construction of social norms, brings into focus what is often denied, that there can be idiosyncratic interpretations of the law which may then become entrenched within its institutional application. And then in the last article, Brendan Walker-Munro considers the increasingly volatile security threats to research integrity in universities and the role of the Australian Research Council in developing best practice to thwart the infiltration of research by unwanted foreign players, maybe unwanted local players for that matter. So in combination, the articles in this 50th anniversary volume make the case that a law journal of this outstanding quality is a valuable resource for those interested in the health of systems within the larger institutions of our society, all of which contribute to a strongly functioning democracy. So Fiona, you got it right, can I say? Congratulations to the University of New South Wales Law Journal on its 50 years and for everyone, past and present, who has made it possible. I think it is an institution. Thank you.
Your Excellency, our hosts, Anne and Michelle, and all our friends at Corrs, contributing authors, colleagues, students, alumni, and all friends of the UNSW Law Journal. My name is Andrew Lynch, and I'm the Dean of the Faculty of Law and Justice at UNSW, and it's my great honour tonight to give a vote of thanks for Her Excellency for her speech tonight, and also to make some concluding remarks about the achievement that is Volume 48, Number 1 of the UNSW Law Journal. Your Excellency, thank you so much for joining us tonight. We're very honoured by your presence and your generous remarks. As a lifelong fan of Dr. Johnson and admirer of the role played by his biographer Boswell, I was very pleased to see the Johnson Dictionary shared amongst tonight and as a starting point for the observation you wanted to make about understanding a broader concept of the institutions that may not be of the state but are relevant to the state and the health of our democracy. And I particularly appreciated the way in which you then wove that towards not just a commentary on the contents of this particular issue of the journal, but the role played by law journals themselves, which Fiona had raised in a perfect provocation, really, for your remarks tonight. So thank you so much for reflecting on the part played by the journal, its relevance and importance for those who will read it and be influenced by it, and also, of course, its permanence. I mean, I think we live in an age where ideas and information are often ephemeral. A journal seems like a determinedly and proudly old-fashioned thing to commit words to a paper that are searchable and findable in a library, whether in a digital or a hard copy form. Institutions are, of course, under great strain at the moment, and particularly when we look abroad and we see institutions that we've previously thought of as more than robust, almost impregnable, experiencing shocks and challenges of a kind that perhaps would have been unimaginable to us just a few years ago. I count law schools as a valuable institution in society, and they are, of course, rightly the subject of public commentary, but they are also sometimes the subject of attack and criticism that is unwarranted. And I think the role of law schools is an important one to constantly revisit, and our contribution to the profession, our contribution to the health of the society in which we live, is in many ways borne out by the kind of scholarship and efforts of the students that produce journals, not just the UNSW Law Journal, but all student-run journals that are in fact a manifestation of the work that universities make possible and can contribute to larger discussions and debates that are important to the health of our democracy. I also wish to comment then on the 50th anniversary of the journal, but I want to make a point that I was surprised has been left untouched tonight, because I did ask Ophelia about it when she first reminded me that it was the 50th anniversary. 50 years, 48 volumes, what went wrong? So it was I'm very grateful to you for not covering that point, Your Excellency. But so I have done my own digging around, and at the risk of making the current executive feel woozy at the sort of leisurely pace of this, the journal was 2 issues only a year until 1997, and 1 volume was spread over 2 years for all of that time. And it's only in 2016 that 4 issues, which really does say gluttons for punishment, was produced by the journal. So I think in part that was because of the abundance of high-quality submissions that were received by the UNSW Law Journal and the desire of our ever-energetic student body to make sure that they would see the light of day by extending themselves to producing 4 issues. I think 4 is enough. I would not advise going to 5. And lest we think that previous editorial teams had it too easy, I suspect that producing issues in the age before word processing may have been just that little bit harder, and also electronic databases. So the workload probably equals out. I want to congratulate all the authors of Volume 48, Issue 1, the entire journal team, and including acknowledging the academic advice provided by my colleagues Professor Rosalind Dixon and Gary Edmond, and to acknowledge particularly the work of Ophelia Zhao as executive editor. That's an important role that will see us through 2025. But of course, Fiona, this is, as I often say, this is your issue. No one can ever take away Volume 48, Issue 1 for you. Those numbers, if you see them on a bus or something, many years from now, it's not triggering because it's a good thing. So it's called nostalgia and reminiscence, and you should be very, very proud of the work you have done as part of an enormous team, obviously, to produce this journal. So very well done to you, and for all those who live with you, your family, your friends who have also played their part in supporting you, I want to acknowledge them too. It's not easy living with the editor of an issue of the UNSW Law Journal. And in closing, I want to thank our 4 premier sponsors, without whom the journal would not be possible, but particularly, of course, to our generous host tonight, our friends at Corrs Chambers Westgarth. We are so proud of the association we have with this firm and so delighted to work with you on so many different things. Thank you for opening your doors to us tonight. It's a real pleasure to be here and wonderful to see so many of you in attendance. Thank you.
Thank you, Professor Lynch, for that vote of thanks, and thank you to Her Excellency Margaret Beazley for your insightful keynote address. With Volume 48, Issue 1 of the UNSW Law Journal officially launched, we have now reached the conclusion for tonight's proceedings. Please feel free to remain and mingle for the next 20 minutes or so, and please do not forget to collect a complimentary copy of Issue 48-1 if you have not already. All of the articles in this issue can be found on the UNSW Law Journal's website from tomorrow. Thank you all for your attendance, and I hope you enjoy the rest of your evening.